If you are a foreign investor considering M&A in Vietnam, chances are you have questions, lots of them. And you are not alone. At LTS Law, we have supported international clients from Singapore, the US, Europe, Japan, and beyond in structuring and closing M&A deals in Vietnam. Over time, we have noticed that many of their questions are surprisingly consistent. In this video, we answer the top legal questions that our M&A lawyers receive from foreign investors, clearly, directly, and based on real-world deal experience. Question 1. Can I own 100% of a Vietnamese company? It depends on the business sector. In many industries, such as manufacturing, software, management consulting, and trading, foreign investors can own 100%. However, some sectors are considered conditional or restricted, including travel agency, advertising, logistics, and telecommunications. These sectors may require a Vietnamese partner or place limits on foreign equity. Legal analysis must be done on a case-by-case basis based on registered business lines and the applicable regulatory framework. Question 2. Do I need a local nominee? No, not if the business sector is fully open and you follow legal procedures. Using local nominees, where a Vietnamese person holds ownership on your behalf, may seem convenient, but it creates legal risk and weakens investor protection. In some cases, nominee structures violate foreign ownership regulations and are not enforceable in court. We always recommend transparent, legally compliant ownership structures to safeguard your investment. Question 3. How long does an M&A transaction take in Vietnam? The timeline depends on deal size, structure, sector, and regulatory filings. A simple share acquisition in a fully open sector with no merger filing or M&A approval can close in 4 to 6 weeks. If the deal requires competition authority filing, sector regulator approval, or complex restructuring, it can take 3 to 6 months or longer. Starting legal due diligence and documentation early helps reduce the overall timeline significantly. Question 4. Is legal due diligence really necessary? Absolutely. In Vietnam, legal due diligence uncovers risks that are not visible in financial audits. This includes expired licenses, ownership defects, missing approvals, employee disputes, litigation, or compliance violations. Even in well-managed companies, documentation gaps and regulatory inconsistencies are common. Legal due diligence gives you the knowledge to renegotiate terms, require indemnities, or walk away from high-risk deals. Question 5. Can I pay in foreign currency? Yes, but subject to banking regulations. In cross-border deals where the buyer is a foreign legal entity, the purchase price is often paid in US dollars or another hard currency via an investment capital account. This requires proper registration with the State Bank of Vietnam. Onshore deals between two Vietnamese entities must follow VND payment rules. Legal and banking compliance must be coordinated to ensure smooth payment execution. Question 6. Do I need M&A approval from Vietnamese authorities? Yes, in some cases you do. M&A approval is required when a foreign investor acquires capital contribution or shares in a Vietnamese company under any of the following situations. First, when the target company operates in a business line subject to market access conditions for foreign investors. Second, when the acquisition results in an increase of foreign ownership from below 50% to above 50%. Or increases the ownership ratio of a foreign investor who already holds more than 50%. Third, when the target company holds land use rights in sensitive areas such as islands, border or coastal zones, or other locations affecting national defense and security. In these cases, the foreign investor must obtain prior approval from the Department of Finance before completing the transaction. Failure to obtain approval when required can result in the share transfer being invalidated or rejected for registration. Therefore, investors should always seek legal advice early to assess whether their acquisition triggers M&A approval requirements under Vietnamese law. Question 7. What happens to employees after the acquisition? In a capital deal, employees stay with the same legal entity, so their contracts remain valid. In an asset deal, employee transfer requires consent and new contracts. Labor law in Vietnam protects employees, and termination or restructuring must follow strict procedures. Buyers should conduct HR due diligence and plan employee communication and retention strategies in advance to avoid legal disputes or operational disruption. Question 8. How do I protect myself after the deal closes? Post-closing protection is achieved through strong contract clauses, such as warranties, indemnities, escrow arrangements, and post-closing covenants. These clauses ensure that if something goes wrong after the acquisition, like tax liabilities or undisclosed disputes, you have legal remedies. It is also essential to monitor compliance after closing and complete required filings and updates with the authorities. Question 9. Can I use international law in my transaction? For many commercial terms, yes. Parties can choose international standards for valuation, dispute resolution, and contractual interpretation. However, certain matters, such as corporate registration, land use rights, and licensing, must comply with Vietnamese law. The best approach is to blend international best practices with local legal compliance to create a contract that is enforceable, practical, and strategic. Question 10. What is the biggest mistake investors make? The biggest mistake is underestimating the complexity of Vietnamese legal procedures. Assuming that the deal will follow the same logic as in your home country can lead to missed filings, delayed closings, or unenforceable rights. M&A in Vietnam requires proactive legal planning, attention to detail, and collaboration with experienced local counsel. Investors who prepare properly reduce risk, gain leverage, and close more efficiently. At LTS Law, we guide clients through every legal aspect of M&A in Vietnam. We answer your questions, clarify local law, and anticipate what you may not know to ask. Our role is not just to draft documents, but to educate, protect, and support you from first contact to post-closing integration. We believe legal guidance should be clear, strategic, and business-oriented. Have more questions about M&A in Vietnam? Let's talk. Visit lts.com.vn to book a consultation with our legal team. The right answers lead to better decisions and stronger deals.